We heard over and over again of a no-fault statute in terms of workers' compensation. Okay, so you're dealing with a structure or a statute that says this claim is accepted. The phraseology as to whether this is John said it earlier. You have to work with the insurance company, give them as much possible information, hire that investigator if you need to. You better mount a lot of information regarding whatever is the genesis of the claim. If it's workers' comp, that's the genesis of the claim, then you need to go after and get all the possible facts that are going to drive why am I going to make this ultimate decision to separate this person from my company. Because behind it now is when 1990, we passed at the federal level, and the states certainly fell in line after it. 3 or more employees in the state of Connecticut, you're under the Fair Employment Practice laws, and you have to, your disability is protected. Workers' compensation has been long accepted as a perfected disability. Okay, within the definition of Americans Disability Act is a mental or physical impairment that substantially limits my major life activity. You have a whole list of major life activities, and number one on the list is working. If I cannot go to work, okay, then I am deemed disabled. And as soon as you introduce the concept of light duty, okay, great way to control the costs, but now the employee is quote unquote asking you for an accommodation, okay? So now with all of this stuff kind of swirling around, we like to go back to say the old workers' comp is an at-will statute. I can ask this person to leave any time that they want. Well, let's end the seminar now. We have a bad employee, just tell them to go. You can't do that now, obviously, in light of all of these employment laws that are swirling around out there. How many employers in the room, 50 or more, as soon as somebody goes on workers' comp, you're now designating them to go on family medical leave. Okay? You're running which you have a right to do. You're running the family medical leave law concurrent with the FMLA, and you're doing it not about the money, you're doing it about the time. So you don't get double dipped on the time later on. Person comes back to work after 25 weeks on workers' comp, you forget to designate, they walk in the door and say, I want to go out on FMLA. Okay? But the problem then with FMLA is now you've given me job care protection overlaying workers' comp. Now you have a job care protection piece that's bumping into the workers' comp. There was a wonderful paper written a few years back, I don't know how far it goes back, by a Connecticut attorney, and they called workers' comp, ADA, and FMLA the three-headed dragon. They called it the three-headed dragon, okay? The idea of these things coming together. So basically, old school law, you would say, easy to terminate somebody on workers' comp. Problem is, you qualify for the Americans with Disabilities Act day one of employment. I come to work for you, I get in a car accident day one of my employment, and I become disabled. I may not be injured on the job, but now I have an overlapping out-of-work injury, okay? Now that employee comes back to work, something happens maybe on the job, you take your victims as you find them. My bad back follows me into the workplace. All of this stuff is swirling around. So I would say you really have to, this is a stop and gather the facts moment. What's going on with the workers' comp claim? If that's the genesis of the claim, what do I have? If I have a person on light duty, I now have an ADA situation. The ultimate problem with the Americans with Disabilities Act when it changed in 2009 affecting workers' comp is they added one huge component to the ruling of the law, which said a leave of absence in and of itself is a form of accommodation. You used to be able to say, go on your FMLA. When FMLA ends in 16 weeks in Connecticut, then I can make the decision about separating employment. Okay? So I wait my 16 weeks out, tell you to go away. Can't do that anymore if you've been in 15 or more at the federal and 3 or more at the state level. You now have to say, is this person making a reasonable attempt to return to work? That's really kind of the only standard under ADA. So you're going to be back into your medical information. You're going to be trying to match your workers' comp up with your ADA, saying, okay, if I want to control my costs with light duty, then I want to, then I'm involved in an ADA workers' comp overlay. And it's going to be extremely difficult because one of the things that I am searching for, and if anybody has the answer to this one, there is nothing that I have seen in any case law, any statutes anywhere that say how long somebody can be on the ADA. The best news that I talk to the attorneys throughout the country, throughout southern New England, throughout Connecticut, say that you're probably dealing with somebody who's going to be on your rolls. Again, they're not getting pay, they're not getting money, okay? After the FMLA runs out, the health care protection goes away, but they have job care protection. They have that last rung on the ladder. You're probably dealing with somebody for upwards of a year. That's what they're saying. And when I refer the cases, because I'm an attorney, but I don't practice law within the association, I send them over to the attorney. They're looking to match up case law with case law to say, in this particular situation, how do we feel? So you better have a really good story of stuff that happened before they went out, stuff that happened when they came in. You better have some real concrete fact. They stole from me. They did this. I better hear something when I'm giving advice and counsel on what we call our hotline. I want to hear that this person did something that rings the bell on the at will. And at will is now becoming what I call at will plus, documentation plus equity. It's moving a little bit more towards a just cause standard. Unless you violate the drug policy and have drugs in your possession, unless you're committing workplace violence, unless you're stealing from me and I have you, and even most of those situations, we still want the facts. We still want the facts of what happened underneath. So pulling that trigger on termination is very, very difficult in light of how the ADA and the FMLA and bump into workers' comp. You have to have all three in your scope, and you better have someone who can kind of look at all three of those together for you. You might have somebody who doesn't qualify for FMLA. They haven't been employed a year. That one's off the table. But ADA starts from day one, and ADA and workers' comp have an overlap that has to be appreciated. It has to be looked at for, am I terminating someone who has job protection? Now, along comes Obamacare, and we used to be able to say under Obamacare that when you're out of work under the Americans with Disabilities Act, okay, workers' comp overlay underneath it, that you don't have a right to continue your medical insurance. Well, I'm sure you folks have now heard about the stability period under the medical for companies 50 or more. If you're on your stability period, you have a right to stay on your insurance for a whole year under the stability period. Well, you cannot kick somebody off under ADA now if they qualify as a disability. You have to leave them through the stability period, okay? Because that's what the stability period is all about. So now we used to be able to say, you can middle somebody, you can take their money away, you can take their protection away, and all they have is a job. Well, now they're not getting any money. Well, now they're getting health care too. So as John said, you got to work with getting people back to work and getting them back on the job and trying to rehabilitate them. The Americans with Disability Act has one underlying premises. It's work with me before you throw me on the scrap heap law. You got to work with me. America is getting older. People are gentrifying, and it's basically put people back to work and try to work with them before you terminate. So it's going to make sure that you did everything. You have to treat people like they're your best employee before you terminate them, so you can say in equity you did everything that you could do.